Hi, Tony DeWitt here, Missouri appellate attorney and a guy who likes to make the law make sense on YouTube. I have a question for you today. Should you lie to get on a jury? I'll have more on that in just a moment. There have been some really great examples recently of jurors that did their job and did their jobs well. They were fair and they made the right decisions. I'll give you a couple of examples, the Rittenhouse trial being one, and the Elizabeth Holmes trial being two. As you'll all recall, I predicted that they probably weren't going to convict on all charges, and indeed, they didn't. They convicted on probably the most serious ones, and we'll see what happens with that. But there are at least two examples in the last couple of months regarding people who lied to get on juries. The first of those was in the Derek Chauvin trial, where a person who had a t-shirt that read, "Get your knees off of our neck," never mentioned his affiliation with BLM or his obviously preconceived conclusions about the outcome of that trial, and he will likely cause that trial and that verdict to be overturned at some point. And this is the second case where jurors failed to disclose information that should have been disclosed during the jury selection process and that may have therefore tainted the jury pool. The first thing that happens in a criminal trial is voir dire. And voir dire, which is French for speak the truth, is an opportunity for both the state, or in this case the federal government, and the defendant to find out if any of the people who are going to sit for the jury have any biases or prejudices that will keep them from being a fair juror. Before you even get there, usually you fill out a jury questionnaire, and that jury questionnaire form is filled out under penalty of perjury. That means that you have to tell the truth, and if you lie, you can be charged with perjury, which is a federal crime. You yourself could be in front of a jury. So you don't want to do that. You never want to lie in order to get on a jury. Most people, when they ask, what can I do to avoid being on a criminal jury? But in those instances where people want to serve on a jury, it indicates that perhaps they have an axe to grind and they want to grind it on the head of the person that is on trial. Now, Ghislaine Maxwell was charged with some pretty horrific offenses that cannot be named here on YouTube because that's against the rules. So we're not going to talk about what those charges were. But one of the jurors has indicated that as an individual, he experienced one of those types of injury. One of the jurors who actually served on the Ghislaine Maxwell jury indicated that he had suffered the type of injury that was being complained of in the Maxwell case. Now, as a result, that alone is not going to get Maxwell a new trial. What's going to happen is she's going to have to show that she could have removed him for cause. She is going to have to show that this juror, if he had been honest, could have been challenged for cause. That's a pretty steep hurdle. And neither the Supreme Court nor the Second Circuit, where this case was tried, have been particularly amenable to challenges for jury nondisclosure. Most of the time, that winds up going against the defendant. It's a very rare case where a new trial is granted because jurors fail to disclose things. And this is a cut from a case that shows exactly how difficult that is for a person trying to get a new trial. Under the McDonough test, which is the court case that determines this, a court must first find that a juror answered a question dishonestly. The Second Circuit has noted that a good faith failure to respond, though mistaken, does not satisfy the first prong of the test. The court must then determine whether it would have granted a challenge for cause based on a truthful answer. Challenges for cause are generally based on a finding of bias. The difficulty of this showing is evident from the fact that no verdict in the Second Circuit has ever been overturned on the basis of juror nondisclosure under the McDonough test. There is a serious issue here that needs to be addressed in both the federal and state courts about juror nondisclosure. Until somebody is held accountable for this kind of thing, and I'm talking about a significant fine or a significant jail term, either for perjury or for contempt of court, until somebody is held accountable, this thing is going to continue. Because I can guarantee you that when you have biases and prejudices, you have communicated those to other people. And you can be investigated, and I can guarantee you that the Maxwell team has ample money to hire great lawyers and great investigators to run down these jurors and find out exactly how deep that particular bias runs. And that's going to be a problem for that juror. And it should be, because until they're held accountable, this kind of thing is going to continue. If you are ever put on trial, you want a jury that is fair to you. You want somebody who hasn't made up their mind about the facts of the case. Most criminal cases involve things that aren't even covered in the media. They certainly aren't covered to the extent of the Maxwell trial. But the important thing here is that in most cases, when you do have media coverage, people do form opinions and they may have biases. And it is simply unreasonable to believe that in a trial that focused specifically on a particular kind of conduct that is heinous, that he would not have remembered that he had experienced this, or he wouldn't remember that he falsely answered that question. So there are significant issues here. And just as a postscript to all of this, let me just say this. I am no advocate for Maxwell. If indeed the facts are as came to light in trial, that she did what she is alleged to have done, again, I'm not going to go into details here, then she needs to spend time in a prison, and she needs to get down on her knees and pray for forgiveness, because what she did was awful. But in order to get into that prison, she has to be put in there the right way. It is better than 10 guilty people go free than that one innocent person goes to prison. And so, from my point of view, if you are even thinking about lying to get on a jury, then you're making a huge mistake. Because if your goal is to put that person in prison, the best thing you can do is raise your right hand and say, hey, that is not what, I'm biased. I can't be on this jury because I have something experience in my past that makes me feel very badly about this particular kind of crime. And by doing that, you make sure a fair jury is impaneled, and as a result, there's not going to be any challenge to the verdict later on. I hope I've cleared that up. If you found this interesting, please go over here and mark the subscribe button if you hadn't already subscribed, and tap on the notification bell so you can be notified anytime we release a video on this channel. Thank you so much for watching. Have a terrific day.